How to negotiate a commercial lease. If you're leasing a commercial property, there are some special considerations that are important to address before completing your agreement to lease. This article will help you follow a checklist of things to tick off as you reach your decision. Method 1. Locating a suitable property. 1. Speak to the property manager or owner of property in which you are interested. Many commercial properties have a notice posted telling potential tenants who to contact about leasing premises. If you are interested in a particular piece of property, find that notice or ask a current tenant who the property manager is. Then contact that person or agency to discuss the leasing the property. 2. Consider hiring a real estate agent who specializes in commercial property. An agent can review listings for commercial property listed for sale or lease. They can also assist with negotiations between the commercial tenant and landlord. 3. Check the availability of parking, ingress and egress, means of entrance and exit, and other items that may affect your business. If your business depends on customers coming in without prior appointments or getting directions, clear signage will likely be a requirement. If you will be loading and unloading merchandise or other items on a regular basis, you will likely require a loading dock. Be sure the property you locate meets all of your needs or can be modified to meet them. If the property does not meet your needs, you should probably find a different property. 4. Find at least 2 properties that suit your needs. This will allow you to compare rent and other costs associated with commercial property in your area. This information will be valuable when negotiating the terms of your lease. Knowing these other properties exist will also likely give you more confidence to turn down a lease you feel is not as good as you could get elsewhere. Method 2. Negotiating terms for the lease. 1. Discuss time and rent. You should determine the amount of time the lease will be in effect and the amount of rent to be paid in particular intervals, monthly, annually, etc. Included in this should also be any scheduled rent increases and lease extensions or termination clauses. Landlords tend to want stable long-term tenants, while new and small businesses generally should negotiate for short-term, 1 or 2-year leases, with the ability to renew without steep rent increases. Common rent structures include gross rent, the most common and is a fixed monthly amount, and the landlord is responsible for all expenses of operating the building including taxes, repairs, etc. Net leases require the tenant to pay for some or all of the real estate taxes in addition to their base rent. Net leases require the tenant to pay for some or all of the real estate taxes plus the insurance on the space they are occupying. Net or triple net leases are usually written only for industrial properties and basically pass on all costs of operating the building to the tenant. Percentage leases are a type of rental arrangement that applies to retailers. In a percentage lease, the tenant pays a base rent plus a percentage of gross income. Rent may go up, and in that case it is outlined in the escalation clause of the lease agreement. 2. Discuss added or included expenses. Frequently, there are additional charges for maintenance of shared facilities, such as parking lots, and utilities that are provided by the property owner, such as dumpster rental and trash disposal. Be sure you know what additional items you are responsible and what is included in your rent. If utilities are billed to you by the property manager, be sure you know if these are individually metered for the area you are leasing or if they are apportioned by square footage or other metric. Ask the property manager to disclose all fees you will be expected to pay to the landlord. 3. Discuss any initial modifications to the property. Some properties offer build-out options in which the property manager will make certain modifications to accommodate the needs of the tenant. Often this will result in an increased rental price per square foot. These may include adding or removing walls, laying carpeting or tile, or installing particular lighting treatments. If the property doesn't offer build-outs, be sure you will be able to hire outside contractors to make any modifications you will need. 4. Discuss maintenance and repairs. In many commercial leases, the tenant is responsible for maintenance and repairs to all except common areas. Be sure you know who is responsible for maintaining and repairing roof, walls, doors, and windows, electrical systems, plumbing systems, other fixtures and appurtenances to the property. 5. Discuss insurance. Aside from insuring your business furnishings and equipment that are to be located inside the property, many commercial property managers require the tenant to carry a policy to cover the building in the case of destruction caused by the tenant or their clients and guests. Contact insurance providers to see how much that coverage will cost. 6. Discuss default and termination. In some areas, failure to pay your rent on a commercial lease can result in an immediate lockout. This could be devastating to your business. You should clearly negotiate what happens if either party does not perform the lease as expected. A few questions you will want to consider are: what will happen if the property is not vacant or ready for move, and on the date the tenant is to take possession? Will there be a grace period for the tenant to pay the rent plus late charges? Can the tenant deduct from the rent the cost of making repairs that are the landlord's responsibilities? If either the tenant or the landlord decide they want to terminate the lease prior to the date negotiated initially, can the tenant sublease the property? What will be the procedure, and how will any damages be calculated and paid? Method 3. Reducing the lease to writing. 1. Consider hiring an attorney. Landlord-tenant law is very detailed and confusing. If you can afford a local attorney who knows the ins and outs of your state's landlord-tenant laws, it would be best to hire one. See https://www.wikihow.com. Find a good attorney. 2. Put all terms in the lease. Ensure that everything that was agreed upon is in the written lease. If a term is not in the lease, it will likely not be enforced if you have to go to court. If the landlord provides a form lease, review it for all terms. Have your attorney review it if you have any questions. Ask for changes if the written lease does not reflect your oral agreement. If you are writing your own lease, you can find sample commercial leases by searching for commercial leases in your state online. Since landlord, tenant, and contract law are state laws, be sure the sample you use has been written specifically for use in your state. 3. Be sure all parties sign the lease. A lease for greater than 1 year must be signed by all parties to be enforceable. Even for a lease of less than 1 year, a signed lease is higher proof of the agreement than simple testimony. 4. Get a copy of the lease after all parties have signed it. If a disagreement arises, the courts will likely require a copy of the contract signed by all parties to be filed with the court.